Welcome to Penn State Dickinson Law's Profiles in Leadership series. My name is Darrell Lim, and I serve as the H. Laddie Bontab Jr. Chair, as well as the Associate Dean for Research and Innovation at the Law School. In this series, we spotlight extraordinary individuals whose work has shaped the legal profession, advanced the frontiers of knowledge, and inspired future generations. Today's guest embodies all these qualities and more. Judge Pauline Newman is a trailblazer and a public servant whose name is synonymous with intellectual rigor and unwavering judicial independence. Appointed in 1984 by President Ronald Reagan, she has served over 4 decades on the U.S. Court of Appeals for the Federal Circuit, an institution she helped shape during its formative years and whose jurisprudence she has indelibly marked with her thoughtful and prescient opinions. Before joining the bench, Judge Newman led a distinguished career in science and law, earning a Ph.D. in chemistry from Yale and a law degree from NYU, and serving as Director of Patent, Trademark and Licensing Department at FMC Corporation. Her background has given her a deep appreciation of innovation and the rule of law, allowing her to bring unmatched insight to the intersection of technology, economics, and justice. Judge Newman's leadership is not only measured by titles or tenure, but by her courage to stand firm in her convictions, her eloquence in defending judicial independence, and her generosity as a mentor and role model for those privileged to learn from her. It's a privilege to speak with her today about her remarkable journey, her perspectives on leadership and public service, and the lessons she has drawn from a lifetime devoted to justice, reason, and the common good. Judge Newman, thank you for joining us. Let's start. Oh, please go ahead.
Well, only to say that I'm very happy to talk with you. I've watched the very interesting and very important work that you have been doing at Penn State and before to help to bring to the public understanding the complexities of this area of law, which has become, in fact, a good deal to the surprise of all of us who started to practice in this very highly specialized offshoot area of law, to know that it's understood by everyone that the leadership, the technological leadership of the United States is much intertwined with the laws that foster such leadership, and in turn our world international posture depends on our preserving and enhancing that position. So we turn out, you and I and many others now, to be in a very important hotspot of intellectual development, and like every other specialty and complexity, there comes a point where deep thinking and profound understanding is necessary to make sure that we're in the modern world and providing an optimum product to the nation.
Absolutely. So let's start with your journey. And as you reflect on your early years, I want to go back even before you were a lawyer, when you were just yourself, before the life in the law, as a child in your formative years. What can you tell us about what you learned about life and leadership from those years?
Well, as a child and in my formative years, in my high school years, those were the years of World War II. The culture in the nation is unlike anything that I have seen since, even though this was really a long time ago. All of us who weren't old enough to have driver's licenses learned to fly planes, and especially the girls, the women, because by that time the women were ferrying the bombers across the ocean because there weren't enough pilots who were all involved in whatever kind of warfare was going on in World War II. So that the combination of patriotism and then the appreciation, the understanding right after the war that it was science, the atomic bomb, that ended the war with Japan. Because when my high school class enlisted en masse in the Army while the war was still pending, they were told that very high casualties were expected with the end of the war, first in Europe and then in Japan. So the importance, the significance of science, and then the discovery that it's very interesting as well, that so little is known and your mind can really roam was part of it. So that was an environment that I think has never been repeated in the nation, that atmosphere of crisis and dedication has had no reason to arise, I think probably for the better. At the same time, it's very hard for me. I can't take any credit for whatever sort of evolution in education I took because the culture was unlike anything before and after.
So you've been described as a trailblazer, and hearing the experiences that you just shared growing up, it seemed like it was just expected of women in society to step up, serve their nation in whatever capacity they could, regardless of gender roles. Uh, have we, as a country, taken a snap back, you think, in that attitude, in gender parity, if you like?
That's very hard to say. And that's really a very complicated question because when the war ended, and it ended very suddenly, you may recall, and the masses of military conscripts came home uh, to say that they should have priority for jobs and a lot of other things, they're having given up all of that in order to put their lives on the line. So that it's hard to say that some old prejudice against women uh, arose, which have been perhaps submerged because there were some very complex interactions taking place and which have continued and preceded. There are differences between the sexes and in strength and who knows what, and to uh, resolve how in the ensuing decades there have been, uh, we'll call them advances, but the fact that preference in college classes, for instance, might have been given to veterans when there was limited space. Uh, Absolutely, I don't think anyone disagreed or felt prejudiced against or disadvantaged. Maybe you felt disadvantaged, but uh, it was not an issue.
What was your family like in terms of encouraging women to develop their potential? You have an extraordinary career in science even before uh, law. And how common was that in your
Well,
time growing up?
it was not that uncommon, and as I think of it, was certainly not a matter of encouragement or discouragement by the family. Part of it may have been that we were a New York family, and I grew up in New York, and that was a culture of its own. Everyone was an individual, and you did what you felt like doing. You didn't need family support or encouragement or discouragement. My mother was a school teacher in New York, but she quit, essentially retired, when my older brother, was born because he was born retarded. He was what they called a blue baby, oxygen deprived at birth, and she gave him her undivided attention. My father was a lawyer. He was a sole practitioner in New York. He didn't really think, he certainly, we never discussed law as a profession for uh, one of his daughters or not. It, things sort of took the course, there seemed to be no limit to opportunities if there were things you wanted to do in that post-war atmosphere. And once I started going to school, I then went to college in New York, a fine small women's college with a reputation for uh, an education and working hard, and at the same time a love for theater. And I put all those together, like the rest of my classmates. And from then on, there really weren't many decisions to make. The next step just sort of fell into place.
When you say theater, do you mean acting?
Pardon?
Do you mean acting when you mention theater?
Well, no, I was not talented enough, but there at Vassar there was a very active theater group, and we very often took a bus down to Manhattan to see what was going on.
And how did you decide that science was the discipline that you wanted to focus on?
I never decided. I took a course in chemistry. Uh, well, in high school in New York, a few science courses were required. And so I took those courses and I took the others, and they were interesting enough. And when I got to college, I took a course in chemistry because it was interesting. And that was sort of how it happened. I intended to go to medical school, but at that time, again, I encountered the problem that I mentioned, that there really wasn't room for women, and I declined to go to the Women's Medical College, although some of my uh, colleagues did, because I thought that's not the way the world ought to be. And in any case, there were more interesting things to learn in chemistry, and so I went to graduate school.
So I remember at some point you spent some time overseas and you were flying planes and you were on ships. Was that before or after law school?
Well, the various habits of my youth were sort of spread out. The first thing after I got my chemistry degree from Yale, first I went to Columbia for a year to study some more chemistry and make sure that it was interesting and that I might wanted to do more. And then I went to Yale for the Ph.D. Then I went to work as a bench chemist, as a scientist for the American Cyanamid Company. But throughout this period, and this was really a product, again, of the war, the interest in automobiles as they were developing, the interest among high school and college age students was enormous. This was a new toy, a new fascination, and you could get to all sorts of places that were not so easily accessible otherwise. And so I really just went along with the crowd. This was not any kind of intellectual choice that I'm going to go out and be different or be a pioneer, because uh, that wasn't the way. There were certainly other women, other girls doing all of these things. Again, a culture, the post-war culture, at least in the part of the world I was growing up in, uh, was something that I've never seen repeated.
And then law school, how did that happen?
Well, so after 3 or 4 years at Cyanamid, it was time for me to take a vacation, because it wasn't that vacations weren't available in industry, but I had no money. And as soon as I had saved enough to buy myself a ticket on the Ile de France, I took the boat to Paris, and uh, so I arrived there, and I hadn't been there more than probably half an hour when I realized that this 2 week vacation will not do, and I'll need to stay a little longer. And so I had to find some work. It's not easy for uh, foreigners to get work permits. Even now, I understand in many countries. But if you weren't getting paid, you could work. So I and a very large number of Americans, most veterans, had also discovered Paris during the war and had come back. By that time, we worked for tips. Uh, and so I worked in a local Paris bar on the Ile Saint Louis and managed well enough.
Were your parents surprised when you informed them, well, it was supposed to be 2 weeks, but I have other plans now?
Well, I don't know if it was a matter of surprise or not. No, we stayed in touch, and they knew I was all right. And as to how I was getting along, after all, by that time I'd been self-supporting for quite a while, so it wasn't, our keeping in touch was just with the family, as one might.
And what were some of your favorite memories of your time in France?
Well, I haven't really thought about that. It is such an extraordinarily charming city of such pleasant people, because Americans were the heroes. So I suppose that didn't hurt. There were a lot of visits, lots of tourists by then, most of whom were veterans who had fought to liberate Paris, and that was well remembered. And I know it happened really more than once. I suppose something always said that you could spot the Americans, whether it was our haircut or our clothes or the way we walked, but people would run across the street against the traffic and hug me and say thank you for, and obviously because the women were not fighting in the liberation, although they were ferrying the bombers. So it was just thanks to the nation, between nations, for having overcome what had been a terrible time.
And how was your French when you first arrived?
Well, we're pretty close to non-existent, and but you learn to get around, and everybody was very tolerant. If you spoke English, again, you were likely to get a big smile and a hug, and people would talk to you in broken English rather than expect you to speak to them in broken French. And anyway, but by that time I knew how to read the menus in the
And that's certainly one of the important things. So what happened after that, after your time in France?
Well, so I ended up staying for 6 months, and then I came home and I timed my return. I thought that I'd want to go back to the laboratory, and then Cyanamid called me and they said, we've saved your job for you. And I was astounded because when I decided I wasn't going to come home, I sent them a letter of resignation. And so I told them that, and they laughed. I think they, being, having been through the war and perhaps having been to Paris, were not surprised that a 2-week vacation was not enough. And so I thought, nevertheless, that I would see what else was going on in the world, because the tradition really was to take a job and that would be your life. And that took a little while to get organized. But meanwhile, I was living in New York, and there was a meeting of the American Chemical Society, and there was a recruiter looking for somebody to work in New York in the patent department. And I knew something about patents because I'd made some inventions at Cyanamid, and patent applications had been filed on my behalf with people on the staff who would write the specification, because that wasn't considered a particularly important scientific position. And essentially, if you got it right by copying what was in the lab notebooks and so on, that you didn't have to take time away from the bench chemists. So it was that sort of a job. And since I had come home in need of employment of some sort, and this position was available on the spot, essentially. They were expanding the patent department in New York. So they offered it to me, and I accepted and started working the next day. And that was really the beginning of this transition because I'd been working for a relatively short time and observed that it would be interesting to know a little law. And since I happened to be living in New York in Greenwich Village, just a block from the law school, and I knew they had a night class because the night law students would turn up at 6 or 7 at night in all the local restaurants, bars, whatever. So I uh, took the LSAT, and apparently it worked out because they accepted me in the law school. And I just sort of kept going for a while. It was interesting to study law, and it was interesting to live in Greenwich Village. And so that just happened. That was not a master plan. I had not only no idea how long it would last, I didn't really stop to think about how long it would last. There wasn't any rush. And here I am.
And here you are. And I think our viewers should also know that not only has NYU graduated a distinguished alum, but now NYU has a chair named after that alum.
Well, of course, the whole thing pleases me no end.
So what happened after your time at NYU?
Well, so I stayed with FMC, which is where I had been going. I went to law school at night, and I stayed, and it was very getting to be more and more interesting. It was getting to be heavily involved with the commercial aspects of patents and trademarks and the other business considerations that need lawyers. And so I just kept going. And I think I told you there was a period in the early 1960s where I was invited by UNESCO as a scientist. It was through the person who, professor of chemistry at Yale, who'd been my research advisor, who was going to take that position. But it turned out that at the last minute he couldn't accept it. So he suggested to them that I might come along. And it was in the UNESCO Department of Natural Sciences in Paris. And it was as a science policy specialist. And the job at the science policy that UNESCO was working on was related to what were called the developing countries of the world to essentially develop science and technology all around the world uh, rather than having the best scientists leave and come to the United States or some European country to develop the universities and the interests and the business and try and reshape the post-war world because everyone had been involved one way or another in World War II and was really ready for this next phase of culture, whatever was going to happen. So it was absolutely a fascinating activity. I traveled all around doing all sorts of things. Although the fact that I was a lawyer, I had nothing to do, as I understand it, with my take or being offered that position. But if, for instance, there was some kind of legal document to support a technology transfer to or to build a plant in Africa or South America or wherever it was appropriate because either of local raw materials or other reasons, I would also do the paperwork. And that seemed to move things along very nicely. I also drafted some legislation for the equivalent of a national science foundation in a number of nations to help to sort of bridge the gap for support of basic research between government and industry and so on. So it was all very interesting. And so FMC gave me a leave of absence. And initially, it was a 1 year leave of absence. And and then the man who was the boss then of the department said, okay. And he, as far as I know, it did my work. So then I said, I've got to stay longer. There's all these things going on. And I asked for another year. So we compromised on half a year. He said, otherwise, he was going to have to hire a replacement for me. The work just had to be done. It was a very small group. There were only 3 of us. So it was an extremely benevolent industrial employment environment that I had been throughout, both at Cyanamid and at FMC. And in fact, that's helped me, I think, to understand the role of industry and the internal relationships in industry in the national strength.
I think one thing that employers should know or families should know every time you leave the country is you'll probably end up staying longer than you originally expected.
Well, one of the things, because again, as a New Yorker, I, where else is there to go? And to find that the rest of the world is not only interesting, but that they know a lot of things that maybe you don't know and might not learn. And I have throughout now this business where I have law clerks, they've all heard me talk about the importance, not just the significance, but the importance of world travel to their development. They've all taken me up on it. So I think we're all better off for it.
Indeed. So you come back, and what happens then?
Well, and so I just keep on working in due time with the transition, retirements, and so on. I was in charge of the chemical part of food machinery and chemical. We called it the Patent and Licensing Department. We did the IP law. By that time, we had a big department. There were 35 of us. It was a very big company. And they were also grew by merging, and the legal services also. They merged with the American Viscose Company, for instance, along the way, and that was another large merged legal activity of this sort. And so it really just kept on going. I did other things. I was involved with bar associations and the Chemical Society and various in and off governmental functions. There was some State Department advisory committees that I served on. And when Jimmy Carter became president and he put together the advisory group, the domestic policy review that led to the Federal Circuit, at that time, I was the president of an organization called the Pacific Industrial Property Association, which was the 30 largest Japanese companies and the 30 largest American companies. And we got together in very interesting parts of the world, as you can imagine, and to solve our mutual problems. So it was because this Jimmy Carter's domestic policy review generally consisted of people who were in one sort of, I guess I should say, leadership role, or at least visible role in one aspect or another So I was part of that group.
And in reflecting on your time with that group, this group of leaders, what were some of your takeaways, lessons on leadership?
Well, I don't know whether to call it leadership, but what perhaps so, because what I did observe, even more than I had known or understood, is that if you collect the right people in the right structure with the right sponsorship, you can make a difference. And because what happened was that this group, because of its highest level sponsorship by the president and the uh, composition, which was all of the people in charge of anything that anyone could think of, if finally putting our heads together and thinking that something ought to be done, it got done. And quite speedily. I use an example, the Bayh-Dole Act. What's called the Bayh-Dole Act was when the head of the National Institutes of Health was a member of this group. And he told us what I think we all knew, that lots of scientists at NIH really were a little bit distressed that they would make marvelous inventions, particularly at that time, the pharmaceutical biological understanding was growing so enormously ever since the discovery of the structure of DNA in about 1954. It took about another 20 years for that to bear the kind of fruit that has still been going on. And so they told us, they say, we have all these great ideas, but no one will industry will take it on. And we all knew why, because even then, at whatever the dollar was worth then, I think it was, many hundreds of millions to go through the federal approval processes. Now I think the average is a couple of billion. And so, and then just as soon as you get your federal registration, anybody can make the product and sell it for the cost of the carbon and hydrogen atoms in it. And as a result, you'll never get your money back, much less have a viable business. And the reason was that if it involved an NIH scientific discovery, because the nation, in its goodwill and for the best of reasons, if the United States pays for the research, it should be available to everybody. That makes a lot of sense. That was in the statute. So if it was to be available to anybody, there's no way that somebody who puts it through the FDA can take it away and patent it. You couldn't license it exclusively. So once this was explained to this group, and the group also consisted of a lot of the leaders of the so-called public interest, that patents are monopolies and monopolies are bad, and that ends it. And people who essentially had prevailed when the NIH was set up, apparently, I don't know the details, they were allowed to enter into the patent system, but only with non-exclusive licenses. Nothing could be exclusively licensed. So this group thought that's not a very good idea. And after arguing about all sides of the considerations and appreciating that it really applied powerfully to items that had a very heavy front-end development cost and a very easy back-end copying manufacturing cost. And therefore, if you couldn't recover your development cost, you don't spend it. Doesn't matter what promise might be ahead, you'd go bankrupt. So it wouldn't do anyone any good. So having figured that out, and with the consensus of this group, with President Carter behind us, and the path, the specific path to having the bill written and introduced, by Senator By and Senator Dole. I don't know. That was just once it's decided that something is to be done and is to be done in the public interest, it can be done extremely promptly and expeditiously. So that's a long answer to your question of what I learned, the most that I learned. What I learned is that there are ways of doing things because now I hear the same sort of tale of things that are not quite right with the way the patent system is working out or the way the law is working out or understanding what's an abstract idea or isn't and all the rest of it. And everyone sort of throws up their hands and say, well, it'll take us another 10 or 20 years to figure it out and get legislative remedy, and the courts should fix it, but the courts can't fix it if it's contrary to the statute. It's only if the statute enables it, and so on. And that what I realized is that that's not true, that there are ways of doing things if you know what they are, and that this having a high level consensus where every viewpoint is thrashed out. There is no, everyone has perhaps a vested interest in one thing or another, and all the compromises, maybe not unlike what's going on now with trying to get some sort of treaty of peace between adversaries, that someone yields something or other, and with enough justice on your side, and so on, and an adequately profound understanding of the public interest. You can make things happen very speedily. I know this is a digression from something that I have been really lately giving a good deal of thought to, of how we can improve some things that need improvement, and rather than just wring our hands in despair, which seems to be more a matter of human nature than anything else.
Well, what is it you think that gave the conditions for the Carter administration to be able to bring together these extraordinary individuals then, which we need to replicate or adapt today so that we might have something similar?
Well, I think the same sort of thing that Jimmy Carter did, if it's at a high enough level in the government, then people know they're not wasting their time and just sitting around and complaining. And that would take an initiative to pursue. I would do it myself, except for the fact that I've been, as you know, I'm in the midst of this battle for survival. So it wouldn't work if, but it would take, again, I'm sure that there are, despite all of the noise in the press about a lot of people in the administration, that there are people who are looking to figure out what's best for the nation, what needs to be done. And my observation under President Carter is that with the right paths taken, it's quite doable to make progress.
Well, you're showing us the breadcrumbs and the roadmaps for how things were done before. And despite all that's going on, you still actively participate in uh, activities all around uh, the district, as well as most recently on the Hill when you joined us for our innovation forum and spoke to hopefully a good number of folks in that room who will become part of a coalition of leaders similar to the ones that you were part of when the Carter administration formed that group.
It could be, like everything else, it needs a mastermind and needs to be pulled together. It doesn't just happen. And uh, that too. Yes. Now, if as a judge, we're really obliged as a matter of I guess I'll call it ethics, but it isn't really unethical, but as a matter of integrity more than anything else, to stay apart. That if we're going to be in a position of interpreting and applying the law, we shouldn't encumber ourselves by having written the law. And because if we had, we'd probably need to recuse uh, just as a matter of objectivity. And so throughout all the time that I was on the bench, I stepped back from the public activities. I would give an occasional talk, and I would perhaps speak more uh, rigorously to my colleagues on the bench on the federal circuit, but their response was to get rid of me because they didn't want to hear it either. So it's my situation at the moment is extremely complex, but I know that there are lots of very thoughtful people who uh, maybe will take it up because I do think from everything that I see in the press that an absolutely optimum structure in the United States for technological leadership is essential at this time in these days, and to be as certain as we can that that's what we have. Maybe it is what we have. Maybe nothing better can be done. But as one looks around, one suspects that there's room for improvement, if nothing else, because technology has changed so much. And I think it's commonly understood and accepted that the patent law, the way it's been written, really isn't quite adapted to artificial intelligence and to what can be done through AI, through essentially the products of that technology, and to think through with a collection of people who understand far better than I the digital world and all aspects of it, not just the science and the technology, but the economics and the business aspects, and make sure so that although, according to the press, American-made drones are the leaders, and I'm glad to see that. And maybe there is no need, for instance, for changing the law to adjust to AI, but I'd certainly be more comfortable if I felt it were being considered more visibly than what I see.
Thanks. So you talked about integrity and ethics. I want to ask you about your time on the federal circuit. What personal values or principles have served as your North Star, especially during challenging or contentious times on the court?
Well, I don't think that there's been any difference. But when you say contentious times on the court, until now, there were no contentious times. If you had a different view of how a case should be decided, you said so. And the majority prevailed, and the person on the short end, if they felt it was worth the effort to say the other side, would write a dissent. Just as in the history of the nation, there's a culture of the style of writing dissents. You don't mince words, or no one will know what you're talking about. And especially if you've been outvoted, you really need to make clear what the other side of the story is. And I think we all know, and I don't know if Professor Lin does this, but I know Rochelle Dreyfus tells me that she teaches her class from dissents. And the reason she does that isn't to make the dissenter judge feel good, but what she says, she said, you just read the court's opinion. You don't really know the depth of the issues. You don't know what was rejected by the court. You just know what was decided and the reasons it was decided. And you don't know whether there were powerful arguments that made it a very close case, or whatever else comes out by looking at it. So the culture on the courts, I always thought, and I always thought was the culture on my court, is that if you come out differently, you say so. And you write a dissent and it moves on. And the idea of contention never really arose. And still, and again, although maybe I shouldn't dwell on it, this is why I was so surprised, flabbergasted, when my colleagues, essentially got rid of me. They still haven't completely got rid of me, but they're so far, I haven't heard a case in 2 years. And the whole culture of the decisions, for all I know, because since I don't see the briefs, I see the decisions, but I don't see the briefs. So other than trying to dig up what's on the public record. So I don't know the arguments that have been rejected either. And of course I worry about that. But maybe it's my nature to be a worrier. I don't know. But other than that, all of this in terms of contention on the courts, of course there were differences of opinion about a lot of things, not just patents or trademarks, but veterans' rights and what's appropriate and what's fair. We get the appeals on vaccine injury, and within all of our colleagues, the role of vaccines and compensation for injury for children and adults and all the rest of it is full of complexities, and there's always something to argue about, and to try and understand, but not contentiously, although there were some vigorous arguments, but we all have the same materials and the same sources, plus whatever we've brought with ourselves in our heads, and to see changes of viewpoint are rare. Now, I wonder whether changes of viewpoint are being submerged for one reason or another. There are a lot of things to worry about that I've been writing a little bit about what I call judicial independence, because we're seeing so much of that as a matter of politics, of as you know, the president's position is that it's the role of the judiciary to enforce the national policy stated by the president, not your private independent view of what the national policy should be. And that's not a frivolous position. It's not what I understood our judiciary was structured to be. It was more like what King was it, George III, that would fire the judges if they didn't do what he wanted. And so that's not supposed to be the rule. Whether it's becoming the rule in the federal circuit or not, I worry about.
So I do have a few more questions, and I did initially say that we would do this for an hour. With your permission, could we go for another 15 minutes or so?
It's okay with me if it's okay with you.
That's okay with me. Yes.
Okay.
So I want to go back to something that you said earlier about institutions, and the Carter administration, as a result of its efforts, made the case successfully for the Court of Appeals for the Federal Circuit, and so it came to be. If you look at the current landscape that we are in right now, what institutions or what changes in the way that we deal with innovation policy should change to meet the requirements of the current times?
Well, that's a very complex question, which I haven't really finished thinking through. as I have tried to think about and understand why now, at least in my view, the Federal Circuit isn't getting everything right. And I think that it was probably when the Federal Circuit was set up as a national court, it, there was not extra provisions made for the constitutional requirement of advise and consent. That is, that for every other circuit court in the nation, there is an advisory role coming through the Senate, but there isn't for the Federal Circuit because there is no structure. Every circuit in the nation has a judicial advisory function where they review and select, screen candidates for appointment. The Federal Circuit doesn't have that, so that there isn't the balance. Our judges aren't done, but at least that step doesn't take place. So whether that would have solved all of the problems that have arisen, I don't know. The original Federal Circuit, the combination of the judges of the Court of Customs, Cabinet Appeals, and Court of Claims were the handful of some of the most brilliant judges in the nation. As to how they got there, I never had reason to inquire about and to understand. So as to whether the entire structure needs to be revised, something very important and dramatic has happened in the intellectual property area and the structure of judicial review that didn't exist before and has changed the entire environment. And that is the formation of the PTAB, the Patent and Trademark Bureau, within the administrative agency, this vast body of judges doing exactly what the Federal Circuit would have done, because that was what the Court of Customs and Patent Appeals did. So instead, that has been delegated to an administrative body of, I don't know, 150, 160 of the best and the brightest, selected from the patent office and from the private sector. A number of those PTAB judges were leading practitioners, litigators who retired from their practice for one reason or another. Some law firms have a compulsory retirement age and now are making decisions at an extremely high level. And then the other factor is that when the Federal Circuit was formed, our strongest pitch need as to why the circuit was essential was because with regional circuits accepting appeals from the patent office, there were circuit splits, and also accepting appeals from the trial courts. So there were circuit splits, and in many important areas, there were at that time rather significant splits of viewpoint among the circuits, which then might be resolved by the Supreme Court or not. So the opposition to the formation of the Federal Circuit, the strongest opposition came from the American Bar Association. And they put together a panel of big shots, real big shots in the ABA litigators. And what they said is that, yes, circuit splits are what's contemplated in the Constitution as a possibility. It's contemplated that there will be differences within the nation. We're a big nation. And so why shouldn't one circuit think that, for instance, your trademark should be such and such, and another say that you can't get that, whatever, the sorts of differences that would appear either in findings of fact or interpretation. And so that, so we, those of us from the Carter Commission who thought it was important to get rid of circuit splits, came out with our reasons that we've got all these smart judges that who know everything, and circuit splits just to the expense of litigation. And if you're trying to develop something new to make inventions and investments in industry, the last thing you need is the perennial litigation that accompanies circuit splits and the expense and all the rest of it. And so in the patent field, and only in the patent field, we should eliminate circuit splits and give this new court of that got to be named the Court of Appeals of the Federal Circuit sole national jurisdiction at that level. Well, there are arguments on all sides, but anyway, industry ended up on our side. When I say our, because I testified against the ABA and said that the one thing we don't need in technology development are all these differences of opinion among scientists. Everyone has an idea, everyone has an argument. Just end it, have one national court with a national decision and a court that would be patterned after the CCPA, which was even then recognized as one of the most competent courts in the nation because primarily of Judge Rich and Judge Markey. And by the time they put it together with the Court of Claims, they were way ahead because that court was, as judges, half of them had been either the Attorney General and Assistant Attorney General of the United States, who then, because again, they too didn't have any advice and dissent barrier, would put these highly regarded top lawyers in the nation on a court for the end of their career. So we foresaw the brilliance that would come after Professor Metter of Virginia suggested combining the CCPA and the Court of Claims in order to solve the objections to specialized courts that were being raised quite strongly, that we wouldn't be specialized. At that time, as a digression, patent cases from the circuits would have been, I think, 14% of the total. So the Federal Circuit certainly would not have been a specialized patent court. My current thinking, but I haven't thought it all through, is that now that it's resolved, now that most of the new patent cases are being tried under copyright law by leaving out the patent claim and just using the patent technology aspects as a focus for copyright, and the fact that having a consolidated national trademark appeal court was rejected by the Judicial Conference some 30 years ago when it was recommended by one of our judges because the Federal Circuit took the appeals from the Patent Office on patents. So why shouldn't they also have exclusive jurisdiction of trademarks since we took the appeals from the Patent and Trademark Office on trademarks, but not for litigation and so on. So there were all of these complexities. And then along comes the 10 years of evolution of the American Vents Act, which creates this new complex body, which some say is still having its own growing pains, but at the same time is essentially deciding. And then appeals from that body still come from the Federal Circuit, which affirms that body in a very high percentage of cases, not all, but a very high percentage. And the entire structure in the nation has changed. But instead of having cheaper, easier litigation, we have double and expensive litigation. And so I am thinking about whether for the patent aspect of the Federal Circuit's jurisdiction, it should be treated the same way as the copyright and trademark and trade secret aspects, because the technology is the same. And why you have to go to different tribunals for the same technology is certainly not in the interest of, well, it's probably in the interest of one set of litigants, but not in others, because the gamesmanship of litigation itself is more and more complicated. So that's a very long answer to a short question. That's as far as my thinking has come, that the initial reason for formation of the Federal Circuit has absolutely disappeared. And as to whether it should be easy or difficult to restore that aspect, the rest of the Federal Circuit's jurisdiction could stay. It's essentially what the old Court of Claims was doing of the government contract cases, plus they added veterans cases and vaccine appeals and other areas that had their own Article 1 litigation and needed an appellate tribunal, which would fit very well with the old Court of Claims because the United States was a party to all of that.
Oh, thank you. It's a long answer. It's an important answer. It's an answer that I think many people will agree, many people will disagree, but important thing is the answer is out there and it gives people an opportunity to consider the status quo afresh, because I suppose if you think about uh, where things were in the 70s, if people were just content with the status quo, we would never be here. And the institutions and instrumentalities of innovation uh, must meet the needs of the times. And what the answer is, I don't know, but it can't be that let's not think about it.
Yes, yes, and it needs a focus. It needs, uh, well, as we started out, it needs leadership, like everything else, because lots of very smart people will think and follow and contribute, but there's another leap to get it started.
Yes, there are a couple of more questions I want to ask you. One, because you are probably the longest serving federal judge, and having served as long as you have entire generations of law clerks who have come through the ranks, and many of our listeners are in law schools themselves. What is the relationship like between the judge and her clerks?
Well, you know, I never married, I've never had children. I think it's like parent-child. I worry about their future. I tell them things for their own good. They pay no attention and they distinguish themselves, and I end up being very proud of them.
And how far back do these relationships go? Do they continue today? Have you had uh, the children of law clerks themselves become your law clerks?
Well, I have, after all, it goes back more than 40 years, and they've gone on with their lives. And, or I think more, maybe they've just started as interns, but they are in a cycle, and they're very welcome. If they ask me, I say, well, you should get some different viewpoint, that you know how I see things, and however it works, it gives me confidence, a great feeling of confidence in the future of the nation. It doesn't mean it's going to be easy, but I think in the long run, we'll come out okay.
You've been a judge now for about 40 years. For some, it's a lifetime. What lessons have you learned about what makes a good judge and what makes a great judge?
Well, I don't think that I've learned anything that I and others don't know. A good judge needs to do justice under law, and that's what judges are supposed to do. If a judge yields to some sort of pressure, whether internal or outside, if a case is close and someone gives you a push in a direction that's not your primary instinct, I think that's terrible. That's not. I think the role of the judge in the United States has been an extraordinary contribution to I'll call it our constitutional democracy, the confidence in the federal judges that you rely on them. They'll do justice. They may have a different viewpoint, have grown up with a different policy, but they're true to themselves and not to someone else. So to me, it's this thing they call judicial independence, which was really what Jefferson and Madison and Hamilton wrote about. They're quoted in the Federalist Papers that the judge needs to be independent. We hope the judge will be smart and wise, but all of these things put together.
So, what if you could sit down today with your younger self, whether it's that starry-eyed girl flying planes after World War II, or the one who ended up in Paris longer than expected, the one that ended up working with Cyanamid or FMC, or indeed the Judge Newman, who was there in 1984, uh, what advice would you give her? What would you tell her?
Well, I can no longer answer that because I absolutely cannot understand what's been done to me to get rid of me as a judge. Cannot understand. So I don't know how I can advise people to follow my pattern if this is the way the world is structured, that without any review, without any responsibility, I apparently have antagonized my colleagues by either my jurisprudence or my style, or I don't know what. And so, I mean, there is something that I can't figure out. No one's been able to explain to me. So to give the advice of be true to yourself, integrity, truth, justice, I guess that's still what I would say, but I think it's more complicated. Maybe you need to be a bit more worldly wise than I've turned out to be, a bit more cynical about human nature than I've turned out to be. I don't know the answer to that.
Do you have any parting words of advice, reflection for our listeners on any topic of your choice?
Well, not beyond what you've already given me this forum to sound off on. I hope that people will be true to themselves, independent, wise, and adhere to all of the structures that have made us a great nation and a great people, and not be pushed around by someone who happens to be a bully or whatever.
Well, thank you very much for taking the time today to speak to me, and through that, all the other listeners of this series. Thank you again.
Well, and thanks to you, Daryl, and I'm interested in the other members of the series as well.
Thank you.